MB and postgraduate diploma in business administration from the University of Delhi. He worked as an in-house counsel and also as a partner at the leading international IP consultancy, Rouse, for 10 years, heading its India practice. Sir founded the firm RNA Technology and IP Attorneys in the year 2004 and has represented clients from the IT, telecom, apparel, FMCG, confectionery, and finance industries in over 500 civil and criminal matters. Sir regularly contributes to various reputed journals and currently serves on a number of board committees. He was also invited to join the board of directors of the International Trademark Association in the year 2019. We are delighted to have you here with us, sir. We now request you to kindly address the attendees for today's session.
Thank you very much. I hope everyone is feeling well this Sunday morning and ready and geared up to listen to another talk on trademarks. I'm grateful to the previous speakers to set the stage, and make you guys all awake this morning to be hearing on a Sunday morning a very heady trademark session. Let me just try and pull out my presentation that will help me walk you through. Have I got the sharing screen right? Yes, I have. Is everyone able to see this?
Yes, sir.
Okay.
Yes.
Great. So, the digital space is getting a lot more noticeable, as we all see, because, this device that is in our hands these days just makes us talk to the phone more than to the people. So obviously that is impacting the intellectual property issues, and my discussion today, I will be touching on few things, which how the brands are being impacted by this digital space. It's a very wide topic to take everything through the digital space, and the time obviously is short. So I'm gonna be walking you through these 4 broad issues that are impacting the brands in the digital space. So if you would recall, I think that many of the students today have joined, and they probably do not recall that time when the e-commerce started, and most of the people would just buy on the e-commerce portal either the books or the flowers and nothing else. And that too, also we were very, very reluctant to go online. Obviously, that space has sort of changed, and of course, a shift to the digital world has happened because of the COVID acting as a catalyst. But at the same time, I think it's my view that, the 2 things that happened in the last 5 years that changed everything was, one was what I call as a geo phenomenon, whereby, cheap data plans of 1 GB or 2 GB every day. And so, people, we have this habit that whenever something is free, we don't let it go waste. So it just hooked everyone to their phones, and these smartphone devices were in everybody's hands and everybody was using them. And then I think the digital wallets made a big difference. A lot of people were quite hesitant to use their debit and credit cards online. And once the UPI wallets, you can scan and send the money across very quickly, that has changed the entire face of how the business transactions, or business to business or business to consumer transactions are done today in the online world. I was so surprised to see that even a small thele wala standing on the roadside selling the some kind of a juice has a scan picture of Paytm or some other UPI wallet where you can actually just pay by that. And people have started to say, look, I don't want it, the cash, just send me by the digital transaction. So I think that's one of the things. But then of course, with a country as big as India, where we have so many infrastructural issues, the digital world was lapped by everyone because there was people didn't wanted to go, they didn't wanted to travel. The banks did not have enough money to invest. Everybody was thinking how I can push down my cost. So the only alternative was let's go digital. Uh, Another phenomenon which kind of happened and why the goods started to sell online is in the early days, the luxury goods never wanted to come online. And most of the people would say, if I want to buy a Mont Blanc pen or an LVMH, a Louis Vuitton bag, then I must visit a store. I would experience, and of the kind of the effect of buying there, standing, and you being served a glass of champagne in the Louis Vuitton showroom in London, and that whole experience used to add to people's buying habits. But things started to change, and slowly and gradually, and now in a big way, every luxury brand has created their own apps, they've created their own websites, and they're giving you the same kind of experience online as it used to happen in the brick and mortar world. And so, why I talk about luxury goods is because 25% of the statistics show that 25% of the counterfeit goods that are sold online are actually luxury goods. And primarily, there's no brainer. It is because the margin of profits that are there in case of luxury goods is much higher. Uh, at the same time, I mean, as the counterfeit goods are available, they are being sold. One would imagine that it would be easier today to, enforce for a brand owner its rights in the online world by just writing to the Amazons or Flipkarts of this world and to say that, look, please stop it and take down, any counterfeit goods that is available. This particular, is something which is counterfeit and I don't want you to be selling it. But unfortunately, that's not how the story goes. The There is what we call as safe harbor provisions within the online world, and before that, I think one needs to understand that the Information Technology Act talks about the intermediary. So, anybody, you can imagine an intermediary like in a physical world would be someone who is a shopping mall, a creator who creates and run, let's say, the DLF runs the, the Emporio in, and they just create shops, they sell it, they let it out to the other brands. And let's say one of the brands inside the shop is selling the counterfeit goods. Is the DLF liable or not? I mean, there is obviously some case laws to that effect, that what liability should our owner take for a tenant. But then, let's just say that to build that ecosystem, we have a concept of intermediaries saying that, look, when the Flipkarts and the Amazons of this world are asked that what are you doing, they say we are just facilitating the transactions, we are only an intermediary. It's like saying that, look, I mean, if you have a phone connection from a company, let's say Geo or Airtel, and if you use that phone to make a threatening call to someone or a ransom call to someone, should Airtel be liable? The information technology law says that no, they're not liable because they just provided you a service. They were only facilitating that, and they're merely an intermediary. So that's the concept under the Section 21W of the Information Technology Act. Follows from there comes the Section 79, which provides for the safe harbor provisions for to the e-commerce operator, in order that they are not held personally liable, but the bar on the intermediary is not an absolute. They are required to observe certain due diligence. And I would summarize by saying that, look, there is a lot of tension when it comes to the brand owners and these e-commerce portals. The brand owners would expect that every e-commerce portal should keep this space free from any kind of counterfeits. Once we have made them known, then they should be actually removing those goods. The e-commerce portals do have what we say take down notices. They have an abuse policy in their terms and conditions. They are required to do so by Section 79. But the way the case law has developed in this area, the early days would say that, the more onus was given to the brand owners. And they were told very clearly that unless you send those particular URLs to the e-commerce portal, and they are not supposed to, go and search for you what they, what is happening on their e-commerce site. Um, and only when you inform them, and if they do not, under the the guidelines that have been laid down also under Section 79, unless we inform them, and if they don't take the notice within those 36 hours that are specified, then only you can come to the court and say that, look, he or the e-commerce portal should not be given the protection as an intermediary, and but protection under the safe harbor under Section 79. A lot of time brand owners, when we work with the brand owners, they are saying that, look, how much can we keep monitoring? I mean, why should it be our responsibility only? And therefore the jurisprudence on this part of the law is still developing. The early days, as I said, this is the first ever case. I'm not going to go into the detail because of the shortage of time. I would urge you all students to sort of go back and read this case law if you haven't. Then this was the first ever case law, case that came out from the Delhi High Court, which went up to the division bench of the court on the liability of intermediary. In this case, it was MySpace. I'm sure you haven't seen MySpace at all. This used to be an early days mishmash of what we currently have as Instagram and Facebook. So, it was kind of a combination of that. They actually hit 1 million users at some stage as well. And so pretty popular. You could actually upload any music, etc. So T-Series was not happy about that their music has been uploaded by the users, and, there are file sharing going on. And so a case was brought, and they said that they should have an absolute liability, and they should they can't be taking a safe harbor. So there were the contours of the safe harbor provisions have been laid down under this particular case law, and the court went on to say that to hold in the end that it is not possible for a an intermediary, in this case MySpace, to actually T-Series providing them their entire library of, let's say, music and songs, to go and search and remove it. They will have to specifically provide them the URL, and if the URL is provided, then they would have to remove it as per the guidelines laid down under the Section 79. There are specific guidelines which have been laid down by the government, and recently you would have noticed it is much in the news because those intermediary guidelines have been expanded to include the publishers. They've been expanded to include the and there is an attempt made to define what is a significant social media entity, and what is based on the number of users. It is my personal view that this space is actually muddled also because whenever the intermediary guideline law comes out, we are trying to hit both the social media entities as well as e-commerce portals with the same sort of guidelines, whereas the two are completely, in some respect, very different to the function which a Facebook or a Twitter provides to to the consumers, and the interface that happens between them in terms of the technology who uploads it, compared to what we see at the Amazon, where there is a better control, and that is actually resulting in consumer buying it. There the information is being shared, and at times we've seen when it comes to information sharing, and when the information sharing is free of cost, people don't care what they upload, and so all sorts of things happen there. But that's again my view, and I feel that as Australia has recently enacted a law which is called the Online Safety Rules and Law relating to that, something similar probably will happen as time goes by, and we may see that the two are separated. So as the MySpace judge, after the MySpace judgment, there are series of other decisions which are came after this. There was a case brought by Kent RO on the design side of things, and they wanted the e-commerce portal. I think in that case it was Amazon and Flipkart both, to remove certain designs of their RO, machine to be removed. And again, the court applied the principles of what was laid down in MySpace, saying that, look, intermediary, you inform them, they will, and I think the another interesting mix in the whole story is also a decision led by the Supreme Court in what is popularly called as Shreya Singhal case, which was actually challenging the Section 66A of the Information Technology Act, which was on how much. And as we were seeing, a lot of people in terms of free speech were being hauled up by the enforcement authorities. And in that challenge, the Supreme Court remarked in one particular paragraph. It's a very long judgment. If someone who wants to read it, it's quite interesting as well to know how the courts have dealt with the online space. And it's one of the very early judgment of the Supreme Court. The remarks that came from Supreme Court in that judgment was that the e-commerce portals are not the judicial authorities. They are not supposed to know what is infringement and what is and in many cases they can go and ask the person who is requesting a takedown, which is effectively removing the products from their e-commerce space, a specific order from the court. So you would see that the early developments have been more in favor of how to protect the e-commerce. This slightly started to change with what we call as the Skull-Candy decision, and there is also the Amway decision on the direct selling entities. Amway products, as they are sold under a different code by the ministry, which is called the direct selling. The Delhi High Court in this case of Skull-Candy, let's take Skull-Candy as an example, which was also followed in few other cases. The single judge of the court, and incidentally, she's also one of your chief guests. She wrote that judgment, Justice Pratibha Singh. The judge culled out the tasks that are performed by Amazon in order to facilitate a transaction. And so, like we all have experienced Amazon, so this is not something new to you as well. They advertise the product, they actually pack the product, they deliver the product, they take away, they accept money from you, and at every step of that transaction, she outlined that there were 26 tasks being happen, based on that, said that, look, to me, this does not seem to be just an intermediary. There is more to that. And, although the matter went up till the division bench and, the judgment has been stayed, but an appeal is pending. So we will see how that space, sort of evolves. Last but not the least, I found this remark from this is one of the things which many times when the e-commerce portals are doing the transaction, or even the social media companies say that look, I am not playing any role. I'm only a facilitator. I do not, I have an algorithm written, and the users come in, they upload the stuff, they they buy the things. My role is only of a technology. And so here in this case, where the Reliance was feeling the heat from lots of job postings on the Quicker, of people working, their brand names geo being used very indiscriminately in a number of places, requested for takedowns. It would happen, but it would come back. A usual story, one of the things which brand owners completely dislike. Sorry, my bias is towards a bit of brand owners because I do represent brand owners in this story. So, I'm taking that disclaimer, because I cannot separate myself from the brand owner. So, whenever I'm looking at these cases, I'm speaking more from the brand owner side. I'm sure someone who would be, more working on with the e-commerce portals can tell you and give you a different twist. And he would have obviously many other stories in these cases to narrate. So in this particular case, if you see that there was very, very strong remarks coming from a judge of the Delhi High Court saying that, look, when you write an algorithm, you're not doing a charity. You are actually pulling your search engines, or your each portal is actually configured in a manner that the when the users come there, they are able to see those results. So don't give us this that I am not an active participant because I've written an algorithm and that algorithm is working for me, because that algorithm is actually written by you, and you need to have a sufficient due diligence. The matter is still pending, and we watch this space for more development. Last but not the least, I've not covered a recent very long judgment written again on the issue of trademarks being used as a part of the AdWords program. There's a case against Google which has been decided recently, and the one of the benches of the Delhi High Court has very clearly said, even though that the crux of the matter there was that while I don't know how many people are familiar with the program called AdWords by Google, whereby what they do is that they actually auction certain words, and you can, because when we go to when we search on any website, or sorry, on internet, we normally put a word, and those keywords actually trigger the search results, whether organic or sponsored results. So AdWord programs of the Google actually sells those keywords. Certain keywords are very popular. So the question before the court was whether those keywords which are not actually visible, to the public when they're doing the search, because the keywords work in a manner that there is an algorithm written. Can they constitute a trademark infringement in case those keywords are actually a brand registered by someone? And the court has come to the conclusion, yes, that would amount to trademark infringement. So, I'm sure that's just a first, case, which will obviously go back up till Supreme Court, because this litigation has just started. So coming to the second part of my, second subject that I wanted to sort of touch upon was the domain names. People thought, most of us thought that domain names will become less important as the, space grows. Many apps would be created. People would go there. Yes, apps are becoming very popular. So people skip the websites now. The social media, or social commerce through the Facebook and through the Instagram is also becoming very popular. So people have stopped making the websites, but the still the domain names stay there. Most companies want to create their own websites. Today, even if you go out, typically, maybe, at my age, I do that, that, if I go to a fair, if I go to those, anywhere, and I see something, and if it lingers in my mind, the first thing I do is just go and check there, whether that domain belongs to them or not, what is happening, that's my first port of call in terms of, how the, domain, whether the person is available online or not. So domain names remain important. The question that I've just said so creates a strong image for your business, helps you build direct relationships. So again, we will come to that. Obviously, what is happening with the whether it is an app or whether it is your own website that you create through domain name, it'll help you collect all of that data about your consumers. And if those domain names were not there, then you would be seeing the websites, as I give in my first example, those numbers, and someone translated those numbers into a memorable word, and that is how they were started to be called. That is how the domain names became, because it was obviously difficult to know all of those, remember all those numbers. Now, the issue on the domain names became important because people started to say that domain name is an address. It is not a brand name. And, in the early days, that was a big debate. Also, the domain names for the from the point of view of a company, with a brand company, whether it is an FMCG or whether it is a media company, also become important, because I was speaking to this, someone from the Colors channel the other day, and he said that before we launch any of the shows, and to clear the brand name, and you heard about how the trademark clearance happened in the first session, I'm assuming, and the importance of the brand names. The digital world has become so important that everyone actually goes and check whether domain name is available or not, whether I can create a Twitter handle, whether Facebook page I can create or not, because the consumers naturally expect that when they're looking for some information relating to that particular product or that particular show, there should be an associated domain name there. So uh, how this space is getting muddled is the fact that domain names are the least sort of regulated space. Anybody can register the domain name. There are no KYC requirements. There are the squatters can use privacy protected, and that is again legitimately allowed by the ICANN, which governs the a lot of UDRP policy. So in terms of disputes on the domain name, there are, let's understand this, that, the last portion, which is the .com, and, for India, it is .in, is what we call as, the top level domain names. They are called as TLDs, or top level domain names. And then there are country specific domain names, and they're called CCTLDs. So country code top level domain names, which is for India is .in. Most of the time, the countries would either, when there is a domain name dispute, the disputes are resolved online through what is called the ICANN administered policy on domain names, Uniform Dispute Resolution Policy, or UDRP. India has many countries, even for their country specific top level domain names, they simply say that we will follow the procedure adopted by UDRP. India has a specific policy, what we call as the INDRP, or .in dispute resolution policy. It is modeled on the same line as the UDRP, but it has still a different policy, and we govern it under the Arbitration Act. Anyway, so the trouble for the brand owners in terms of the domain name, as I was mentioning, is that you could register a domain name. Anybody can register a domain name without having to actually provide any documentary evidence and support. No PAN card, no Aadhaar card, nothing required by you. You can even avail a privacy protected service to hide your your addresses, your name. It would just say privacy protected or proxy services as a registrant of the domain names. To add to the mix is the GDRP, which is the global data regulation policy of the European Union. And so after 2018, because they do not want the personal data of natural person to be shared online without their permission, at least that is the law in EU. We are still formulating that law. It's considered as the gold standard in terms of the data privacy protection. They cannot disclose the name of the people, and there's a lot of tension between the brand owners and the ICANN on this issue, simply because everything is redacted. You don't have the information. Someone is the typo squatter. Let's say your own someone, if let's say tomorrow creates a website which mimics or has a domain name similar to the VIPS. I mean, and you would like to take an action against that particular person, and if it is an individual, it could be all data protected, privacy protected, and so you will have to write to the domain service provider, asking him, requesting him for the information, or file a complaint and against that particular privacy protected person. So the whole thing gets delayed. If you would like to go to the court, again, there are issues. Who are you filing the case against? Who's your defendant here? And so again, you go back to the domain registrar and ask him for the information. So I just wanted to highlight that, and the issues surrounding the domain names more from the practical and business point of view. For the case to be read, I would strongly suggest the students to read this particular case on the domain names. This was the first ever decision which went up to the Supreme Court. This actually laid down, so the dispute was on the SIFI, which in early days was one of the internet service providers by Satyam, no longer a service probably today, maybe in South India, I don't know. The matter started at the Karnataka High Court, where when a real estate agency got the same similar domain name but with a different GTLD, and the question was whether domain name can be considered as a trademark, and the Supreme Court finally settled this dispute and said that domain names are akin to the brand names, and that's the kind of principle that is now followed in every case on domain name that is brought before the Indian courts. So, considering the time, I won't sort of go into the more details. Do read this. Citation is here. The Supreme Court has very clearly said that no, it is not just an address. The domain names are memorable, so therefore they are brand names. Job scams in the online world. So again, from the trademark, brand owners' point of view, this is a big issue that is becoming for them, because closely following from the domain names, when you would see a lot of companies creating fake websites, using the brand name to ask the applicants to apply for them. It's a usual thing. I was assisting Google in one of the such similar scam, where not only a fake website was created, the people had actually created an office, decorated the office with the entire Google, color schemes. Everybody was drinking coffee as well, which had Google written. People were called for the interview. Money was charged to them to, book their tickets to come to Delhi for a final interview, and it turned out to be a complete hoax, and this activity, because of the online space becoming popular, is getting more and more, noticeable, and government is also obviously concerned about this. This was one of the cases that we handled on behalf of Hard Rock. We know Hard Rock Cafe, but they also run hotels in many places. This particular person was, created a website called hardrockcanada.com and would advertise on many various job portals, asking people to apply. And they were very careful. They would not apply for white-collar jobs, but more like blue-collar, for the plumbers and electricians and for the odd jobs. And people would, fall prey to that. And then they would ask money from people to in the name of either getting medicals done or for the visa fees. And went through the entire process. When we went through, we found that so these are the kind of letters that were being issued as well to the people. You can see that this is a clear brand name issue here, and it's becoming so much that many times you would have noticed that there are caution notices being placed even by companies to say that, look, do not fall prey for anyone asking you to offer a job, because we do not sort of ask any money for anyone to apply for a job. And so this is when we investigated this particular thing, the chain went up till Guwahati. So, a phone call was coming from Bangalore. The money was being withdrawn through an ATM card in Delhi, and the bank account was opened in a small place in Guwahati. And what they had done was that they had, tricked an old lady and taken her KYC documents, open a bank account, and taken away all the checkbooks and the ATM from her, and that's how the scam was operating, so that they don't get caught. Ultimately, a complaint was filed before the cyber cell. Unfortunately, nothing much has happened since then for me to, sort of say that, yes, it was a happy ending of some sort. So I think probably we get it, or, we have seen a lot of hotel people get targeted. There was, again, someone who created a scam for a Ritz hotel in Paris, offering people jobs, issuing them letters, like this, even created a website called ritzparis.com, proper stamp everything that'll be issued with a Paris this thing. And people were obviously, sort of believed it, paid money. Ultimately, we had to go to the court, get an order to close down the website. So another implication for the digital world, as you would see, is that it is so easy to create a website, and make a little typo, letters here and there, and many times people would not notice, and they would fall prey to, these kind of schemes. And therefore, a large amount of time of the brand owners these days, and a large amount of budget is going towards monitoring the digital space. There are obviously, tools available. There are, you can't physically do every monitoring program, in the digital world, but it has become another avenue, more than the brick and mortar, in terms of, counterfeit goods and infringements. When it comes to the what we call as the job scams, or the digital world issues that the brand owners are facing. So I will quickly touch upon how am I doing time wise. What time would you want me to finish? I can tell stories after stories. If you what how much time do I have?
So we have half an hour with question answers to be dealt with.
Okay, great. So I'd like to leave more time for the question answers, because that will generate probably a better discussion. So just touching on this, I mean, this is obviously not something which is a pure brand issue, but it is becoming again a brand issue because of the fact that the data theft is in particular is happening more, in the name of the, taking the name of a brand owner. You have to sort of, go to a Facebook to share your data. You have to go to a, any other social media sites, or e-commerce portals are collecting that data. Or every time you visit a, a store, which is a branded store, where they ask you, sir, can I get your mobile number because I want to send you these special offers, or I'll send you a coupon or something. That is how, in the name of the brands, the data is being collected. I mean, obviously in the, tier one cities, we all are still a bit more careful in terms of volunteering our information in the name of the brands. But if you imagine, as you go a little far from here to the tier two, tier three cities, in the name of the brands, people actually are able to get a lot more out of people. One of the interesting, I'm sure many of you would have seen the series on Amazon, which was about how the phones are being used. It's called, I think, the Jamtara. If people haven't seen it, you should watch that. It's so very interesting how, our law enforcement is so falling behind what these people are able to do in terms of, making calls, getting the data collected, and then, making a fraud. So that is something which we are, I mean, this is obviously given, I mean, some of the places how the data is collected. Again, this is a big area, both for, companies as well as the government. Knowingly, unknowingly, every one of us is leaving the data footprint, whether searching, whether, visiting places, or even in public spaces, because there are so many of these, the CCTV cameras which are installed in every nook and corner of Delhi today, that even if you don't want to, you never know who can actually take back all of that information and analyze the data and, come back. From the brand owners or the company's point of view, another cause of concern to people is, yes, I mean, you're not, going to be at one company for more than few years. People do change jobs. Those days are gone when people would, join somewhere and retire from there. So it's fashionable among the youngsters to just not stick to a place for more than 3 years. People start saying, why you here for more than that? The companies are worried because when they leave, they take away their data, and when they take away their data, there are, issues surrounding what is proprietary, what is non-proprietary, what have I learned, in them. Um, then the companies also are worried because there is a lot of time. Not you alone cannot do everything, so you hire contractors, whether on the IT side, manufacturing companies hire people from other vendors to do part of the job, and then there is information being exchanged. So we have seen cases where, the intellectual property theft occur at that stage where the know-how and know-who is shared among the vendors, among the contractors, with the employees, and they go out and set a parallel business. And this is another area where, there has been still quite a lot of jurisprudence which is to be developed, because right to life, livelihood, and the intellectual property rights are to be balanced, and somehow the courts would like that right to livelihood is given much more preference compared to the intellectual property, so that's something which is taking a precedence. These on the data privacy, obviously we don't have the currently a law as a complete enactment. That data protection bill is still being debated in the parliament. We have read a lot of news recently on the new bill coming out, and we will wait to see that what happens, but this is the something that the Information Technology Act provides here, in terms of what can you do when there is a data theft happening. And I think the focus here is on sensitive personal data, and that definition has also been further qualified by giving examples of what is sensitive personal data which can be protected. um, Many a times these days, when the people leave, the contracts on the confidential information also becomes equally important. uh, so it's almost like becoming for companies, the brands, the trade, this is another area which is causing them a lot more challenge. So imagine data from two sides. One is the footprint that you leave when you go and interface, when you're buying goods, when you are visiting places, etc., or when you are going online to sort of either consume information or buy goods. But then there is equally the company side of things, because they are sharing a lot more data with their own employees. And for us, that is also another area where we are able to where there is a lot more work for companies, the challenges that they're facing in terms of employees leaving, or how to govern their vendors, how to make those contracts in the first place, whereby their intellectual property, their brands, their copyrights, their designs, their patents, everything is in safe hands. And at the same time, care and share also happens with the employees, so that they can actually sort of bring to the table themselves fully. Because if you can't create that environment, then how can you expect the employees to fully apply him or herself? So that's a big challenge in terms of data. We have seen, and cases in many, we have handled many cases where people have set up parallel businesses. And in most of these cases, the interesting part is that when people copy or take away data, they leave the footprint of the somewhere of the older brands, and that helps to sort of establish the chain of that there is something more to what they have. They're not set up this business, or this is not a public information that they have got, but they've actually transferred the data from the old place where they have worked. So I mean, I think this is a very broad topic, and I just wanted to touch upon it because it is very topical. It is on the um, something which I wanted to highlight, that how the not only consumers but the businesses are equally concerned, and the intellectual property theft from the use of technology, the use of the digital space has become so rampant and so easier that it can be a big issue. It is certainly a big issue for the companies. And last but not the least, I was very interestingly, there was a image which was shown on the discrimination of brands in the last presentation. And I just wanted to say that, look, another area for the brands, which is, or for the governments, is the, the newer issues, like, for example, the climate technology, the zero carbon dating. And what we will see in the coming days is that many of the companies would latch on to the, saying that I am a, carbon, zero carbon, or, zero footprint of carbon kind of trademarks being used. And there is a completely different space which is governed by Advertising Standard Council of India. And that could be another complete session on how, advertising in the digital space is actually also another cause of concern for the governments and for the companies to, and how the consumers are being, sort of deceived by those, false claims, and how those, images are of a original product is shown on our website, and what is supplied to you is completely different. The ease of copying that the digital world allows you to do, and the role of the ASCII in that is also becoming more and more important. ASCII is Advertising Standard Council of India. So with that, I think I should stop, and I would like to sort of, share my experiences on any questions that you raise. Thank you very much.
Thank you so much, sir, for such an educational session. So we have a plenty of questions, so I'll just go one by one on each of them.
Sure.
The first question that we have is, does securing a domain name give extra evidentiary value for a trademark, or is it the other way around?
So it can work both ways. So most of the time, I would say that if you have a domain name, that could also help you to kind of establish that you had created those rights. You could either apply for the trademark later on, or you could, do it either way. But, as I said earlier on as well, most of the times, both of them should be done together, because you would realize, I mean, there was a pharma company we were recently assisting, and and they had come out with a COVID medicine with the help of the DRDO. And by the time they could actually launch the product and, they did file a trademark, but the domain names were already gone. So it's almost simultaneously, and then you have to spend money to get them back. So, either do a UDRP or take them to the court.
Right. So thank you so much. So the second question is, could there be a statutory backing to regulate domain names?
I personally feel the ICANN is the regulator in some sense, but it is still not, to the extent that, as I mentioned, there's no KYC. You can create a website today, and that is fueling the counterfeits and the piracy online. And if one is shut down, then you could actually mirror that and create another one. And there is some case laws that have come out on that, but then. I personally think there should be statutorily, there should be something asked, like we have the, today when you want to sell online, at least there is a GST number that you have to provide to sell online. So why not something similar, something has to be done in terms of the domain names as well.
Right.
It's too unregulated.
So much. So the next question is, if you could please elaborate on the meaning of bad faith while registering for a trademark.
So actually, the bad faith is more used in the sense of unfair competition and passing off, which is more like a common law remedy, because it's just gets mentioned in our Trademarks Act, but we haven't got any sort of codified unfair competition sort of law in the intellectual property sense. Yes, we have unfair competition in the form of the Competition Act. It used to be at some stage part of that law, but then it is not. So a bad faith, and I think one could also get the cue from the UDRP and the INDRP policy as well, because one of the things which you can prove under the domain name system is that was the domain registered in bad faith, and they've given examples there. So I would urge that someone who is asking would probably just have a look at that, the bad faith decisions in the If you go to the WIPO website and actually search for WIPO jurisprudence, they have very effectively organized both the point of views on every aspect of decisions that they have, and that could be very useful for you all to read. But on the bad faith, there are many decisions coming out and passing off actions as well, and that those define how the bad faith is treated in the trademarks law.
Thank you so much, sir. So one more question that we have is with regard to data protection and trade secrets protection. Where could one put a distinguishing line between these two laws?
So I think from the point of view of the company, that is always going to be a challenge. You are, as I said, on the practical side of things, today, if you want to set up an R&D laboratory, unless you create that environment in which the inventors can fully and freely operate, and make them incentivize them suitably, that means you're sharing everything with them. Out of those labs will be coming out the inventions that will sometimes be protected by within the contours of the intellectual property. Sometimes it will become just your trade secrets, because you do not want to. And I think the trade secret law, I would also like to sort of share this, is that why it is becoming more and more important as we go, and we still don't have a codified law. US has it on trade secrets, is because the technology is making us, the shelf life of every product is becoming smaller and smaller, and and the patents take a long time for us to register. The copyright law is not an answer, because it's kind of considered more weaker in terms of protection of a technology, at least of softwares, when it comes to copyright protection. So the trade secrets are very important for the companies, and that balance is more a business subject, I would say, than a legal subject. That how do you balance the two? Yes, there are many case laws which says that, look, I give you an example. There was a famous case of an American Express bank, where this lady who used to be a relationship officer left the American Express, and when she left and joined a rival bank, she took away all of the data with her, and obviously it was all in her phone. There was nothing labeled as trade secret there. So bank brought a case against her to say that, look, here is someone who's taken away my trade secret. He or she should be stopped from doing the same thing for at least the time that my contract provides. But the court did not, because right of livelihood took precedence over what was the could be the trade secret of the bank in terms of the the data that she's taken. So it's a tricky area, because we don't have the codified law. One has to show more than, and obviously employees, wherever they go, they will obviously join the same companies or, similar this thing. So that balance is still, tilted, I would say, more in favor of the employees rather than the employer at this stage.
Right, sir. So the last question that we have for today's session is with regard to Google advertising program. So the question is that if a competitor uses your registered trademark as a keyword in their Google AdWords, Google does not stop them. It does not restrict anyone to use another entity's trademark as a keyword. And it does not even investigate or restrict trademarks as keywords, which is an illegal activity. So what can one do to stop such a process or a procedure?
So I think Google has come under a lot of criticism for this. And as I was mentioning, there is a new case decision which has come out, whereby the Google has been told that, look, you at least the brand name, if it is registered, you cannot offer that as an advert. So go and read that. It's a very long judgment, recently just come out from the Delhi High Court. I think it's called Google DRL Logistics or something, search by that. It's the case brought by Agarwal Packers and Movers in terms of their brand name registered being offered as a as an advert or a keyword to be sold on the Google as a part of the Google AdWords program. So the court has held that in that case it is an infringement. Also, the Google policy from country to country differ. In some countries, they say that you can't offer a registered brand as an advert. but in India they were offering. So that's another point of view, that what can you get away with. At the end of the day, it's a business for all of them.
Right, sir. Thank you so much, sir, for such an enlightening session, and also for attending to all the questions that the attendees had posted on the chat box. I would now request Dr. Nipun Gupta, faculty co-convener, to please propose the vote of thanks. Ma'am, you're on mute. Ma'am, you're not audible. You're on unmute, but you're not audible.
Nipun ma'am, you are not audible.
One second. Am I audible now?
Yes,
now
ma'am.
you
Yes,
are
ma'am.
audible, ma'am.
Thank you so much. Okay. Okay. So this is another glitch that we face due to technology. So a very good morning to everyone present here, and to our most valued guest, Mr. Ranjan Narula. Here I take this opportunity to thank Sir to spare some time from his busy schedule on Sunday. I'm sure today our participants have taken something valuable and are going to do some thinking process on all the points that are mentioned in this session. It was indeed a brainstorming session, and I would like to say here that no doubt the field of IPR is very dynamic in nature, and its application largely depends on the progress that is taking place in the society. And as rightly put across by Sir, the area of domain name is one of the field that needs special intention, considering the level to which cyberspace is being utilized for conducting various activities. And this is required in order to ensure that the rights of all the virtual consumers are protected efficiently and effectively. With this, I would like to extend a vote of thanks on behalf of Vivekananda School of Law and Legal Studies, VIPS, and the entire organizing team of Center for Intellectual Property Rights. Thank you, sir, for sparing time and for gracing this occasion and sharing with us your experiences and opinion today on the topic trademarks in digital era. Without your generosity, knowledge, and patience, this talk, or we can say session or lecture, would not have gone so smoothly as it has gone. Thank you once again for volunteering and making this event a successful one. I would also like to thank all the participants for giving us this opportunity and for patient hearing. Thank you, everyone. Thank you so much. Thank you, sir.
Thank you so much, ma'am, for your vote of thanks. I would now like to thank Sir on behalf of the entire organizing committee as well for such an enlightening and wonderful session. We hope to really see you again soon, and probably in the physical mode this next time. I would request all participants from VIPS to please fill the feedback form, which has been posted on the chat box. A separate link has also been provided for students outside of VIPS, and this shall be filled before we proceed with the final session at 12 o'clock. We will be resuming on the same link, so you can all stay connected on this link only, and we shall resume at 12 o'clock. Thank you, and we hope to see you soon.